Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about damages in personal injury cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Ms. Greenway Brown was involved in a series of motor vehicle collisions in which she claimed to have been rear-ended by a number of other vehicles. Ultimately, she argued that she had suffered soft tissue injuries, not visible injuries, that affected her and that she should deserve compensation for those injuries. She was denied compensation on the basis of the fact that the injuries that she suffered were not reasonably foreseeable as stemming from the low-impact minor damage collisions that she had been involved in. This was an inference that the trial judge drew in the absence of any expert evidence, which raised very important questions in her case about whether or not it was appropriate to draw those inferences without any expert evidence and whether or not it was appropriate for the judge to opine about those issues. It also raised important issues about the applicability of some long-standing civil law in Canada, including a case involving an individual who suffered mental distress as a result of a very strange incident. And the court had to grapple with whether or not this case applied in the context of physical injuries or only applied in the context of mental injuries, something that hasn't clearly been litigated yet in Canada. This was an opportunity for the Supreme Court of Canada to deal with the way that soft tissue injuries and the research that we now know is coming out in relation to minor accidents causing significant injuries and potentially head injuries and significant damage in a way that was reasonable and dealt with it from a common sense perspective given the absence of expert evidence in this case and given the inferences drawn by the trier of fact. This was an opportunity for the Supreme Court of Canada to really clarify some of the laws around personal injury and motor vehicle accidents that could have affected people in motor vehicle claims in courts every day in this province. That's the very thing that constitutes an issue of national importance that the court should have considered. And yet, unfortunately, they avoided that opportunity and have left it with an unanswered question about whether or not mental injury or physical injury are to be considered in the same way in these types of cases. Hopefully another case comes before the Supreme Court of Canada before too long, while people who are suffering as a result of their not-at-fault behavior in motor vehicle collisions don't get compensation for injuries that they have. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.